Hello everyone. Today we will discuss another topic under environmental studies and environmental laws. Today we will discuss about international environment laws. We have so far discussed about the Indian scenario of environmental laws. Now we will discuss the aspects of international environment laws. The list of topics to be covered here is introduction, concept of international environment law, declarations, treaties and judicial remedies. International environment law is an ever-changing, constantly expanding, and intriguing topic for the international legal research. When decisions and collaborations occur between nations across international boundaries and treaties or agreements that are made to cooperate for environmental concerns, disputes inevitably transpire because of trade implications for the respective nations, safety concerns, and cleanliness of environmental resources among shared borders or problems with enforcement mechanisms for liability under agreement or treaty provisions relating to the environment. International environmental law is concerned with the attempt to control pollution and the depletion of natural resources within a framework of sustainable development. It is a branch of public international law, a body of law created by states for states to govern problems that arise between states. International environment law covers topics such as population, biodiversity, climate change, ozone depletion, toxic and hazardous substances, air, land, sea, and transboundary water pollution, conservation of marine resources, desertification, and nuclear damage. Major declarations on international environmental law are Stockholm Declaration and Rio Declaration. Stockholm Declaration. This is the declaration of the United Nations Conference on the Human Environment, which held in 1972. This declaration represented a first major attempt at considering the global human impact on the environment and an international attempt to address the challenge of preserving and enhancing the human environment. The Stockholm Declaration espouses mostly broad environmental policies, goals, and objectives rather than detailed normative positions. Rio Declaration. The Rio Declaration on Environment and Development was a short document produced at the United Nations Conference on Environment and Development in 1992, which is known as the Rio Earth Summit. The Rio Declaration consists of 27 principles intended to guide future sustainable development around the world. Customary laws and general principles relating to the environment, such as the precautionary principle and sustainable development, are evolving, but it is arguable whether any have yet become normative rules. The speed with which awareness of global environmental problems has reached the international political agenda has meant the customary law has tended to take second place to treaty law. In the evolution of legal norms and treaties have been the main method by which the international community has responded to the need to regulate activities which threaten the environment. There are hundreds of bilateral and multilateral environmental treaties creating states' rights and obligations. The United Nations Environment Programme and the UN Commission on Sustainable Development have negotiated many of these treaties. Judicial remedies. There is no international code for the environment. All environmental disputes are litigated before a wide range of adjudicative bodies, global, regional, and national, and judicial and arbitral. Many multilateral environmental regimes have non-compliance procedures which are typically non-judicial. Disputes between states concerning international environmental law can be heard in the International Court of Justice, provided that the dispute is between states that have declared the ICJ as compulsory jurisdiction. The ICJ, International Court of Justice, is a court of general jurisdiction that provides advisory opinions and decides contentious cases. Interstate litigation is based on the remedial principle of states' responsibility and international tort law. The ICJ, International Court of Justice, is only able to determine the disputes between states, individuals, and other non-state actors that are not able to be parties to a dispute. Environmental protection disputes between states and non-state actors such as individuals, communities, and corporations can also be heard in the International Human Rights Court, such as the European Courts of Human Rights and the African Commission on Human People's Rights.